Hello, I'm Lynn Holtain and welcome to this panel discussion called Like Chalk and Cheese, Law Degrees and Community Lawyering from the Victoria Law Foundation, the Federation of Community Legal Centres Victoria and Monash University. This is part of the Law and Society Association of Australia and New Zealand annual event this year called What is the Good of Law? I will introduce you to our panellists very soon, but first, all our panel members are on the lands of the Kulin Nation today in southern Victoria, and we acknowledge the traditional custodians. It's my privilege to pay respects to their elders and to all the generations who have nurtured this land for over 50,000 years and continue to do so. We recognise their abiding connection to this land, its waterways and community, and that the lands were never ceded. A few housekeeping matters before we proceed. As you'd be aware, this is a webinar, so only the panellists can be seen and heard, and all your videos and audio is muted. But please use the chat function to introduce yourselves to each other and to make comments, and use the Q&A function to put your questions or to upvote other questions. We have got quite a good time at the end for a Q&A with the presenters. So dream up your questions and put them in the Q&A function as we go. Right, to our panellists. They are Dr. Josica Cooten, who is Senior Researcher at the Victoria Law Foundation, Louise Gibbs, Chief Executive Officer, Federation of Community Legal Centres Victoria, and Associate Professor Genevieve Grant, Director of the Australian Centre for Justice Innovation at Monash University. Just a little background on each of them before I hand over. Josica joined the VLF in August 2020 as our senior researcher. She completed her PhD in the School of Economics, Finance and Marketing at RMIT and has focused on, also has a master's in forensic psychology from Monash. Her research has focused on preventing economic abuse in young adult relationships and financial well-being. In the past, she's worked in asthma epidemiology, prisons, forensic psychiatry, and drug and alcohol services. So as you can see, perfectly suited to an analysis of community lawyering. Josica has worked across industry and community organisations, developing and evaluating resources in financial abuse and financial capability, which of course translates exceptionally well to her work with us at the VLF in legal capability. Louise Gibbs became CEO of the Federation of Community Legal Centres in Victoria, which is the peak body for CLCs with 47 members, in August 2021, so she's a newbie. Earlier in her career, Louisa was the principal solicitor of Inner Melbourne Community Legal, then spent 13 years in developing countries, partnering with people affected by injustice and discrimination to be agents of change. And this included working as an advisor on the Ramsey Law and Justice Program in the Solomons, building the capacity of national lawyers in Vietnam and Senegal, and supporting activists to advocate for the introduction of dedicated domestic violence legislation in 3 Pacific Island nations. And finally, Associate Professor Genevieve Grant is Director, as I mentioned, of the Australian Centre for Justice Innovation in the Faculty of Law at Monash. Her research uses empirical methods to investigate and evaluate the performance of justice systems. No mean feat. She also teaches litigation and dispute resolution, company law, and lawyers' ethics. So, to our topic this afternoon, the community legal sector is a critical pillar in the delivery of legal services. But is it a poor relation when it comes to the career paths that are supported by law school curricula? Today, we're going to explore 3 questions through the results of a recent survey that we undertook. Do law degrees prepare graduates for work in CLCs? If they do, what components of the degree programs are most relevant and effective? And if they don't, how might legal education change to prepare graduates for work in CLCs? So let's start with the evidence, and to take us through the survey results, Dr. Josica Cooten.
Thank you, Lynn. Thank you for the introduction. Good afternoon and welcome to the panel today. So completing a law degree is the first step, obviously, in becoming a lawyer in Victoria, but does this legal education prepare graduates for community lawyering? As Lynn mentioned, we undertook a survey of lawyers working in community legal centres in Victoria to find out whether their formal legal education prepared them for their work in community legal centres. So today I'm going to give you a brief overview of the main project. And this presentation is about one aspect of that survey, people's views of their legal education. I will first present the quantitative data, so some of the numbers, and then the qualitative data, so a bit more detail on what people said. I'll pose a few thought bubbles, which Louisa and Genevieve will then discuss further, and hopefully you'll join us in the Q&A. So I'm basically here as your data nerd for this presentation. So we conducted a survey at the end of last year with everyone who works at CLC, so employees, volunteers, board members and students. The four main aims to the workforce project, which is what we called it, was to investigate who works in the community legal sector, what are their characteristics, what is it like working in community legal centres, how can they be improved, and what would enhance the work of the community legal centre sector. We used two online surveys, a survey to all CEOs at each of the 47 community legal centres and an online survey to all the workforce. And there was a mix of closed and open-ended questions. So first off, just a brief overview of the actual survey used, and you might recognise that law school. I'm not going to tell you what it is because it's a bit of a quiz. So the survey that we sent around was quite long, and I've just received a note about my volume, so I hope that's a bit better now. And it covered a lot of topics. So this presentation, as stated, is looking at legal education, both asked in the demographic section and when they were asked about to reflect on the skills that they needed for working in community legal centres. Overall, the aim of this paper is to look at legal education, and there were three questions that we had for this paper. What factors are associated with their view of how useful their law degree was? What did they perceive as actually being useful? And what would need to change with legal education to better prepare graduates? So in the survey, we had three specific questions, but we only asked these questions of people who had completed law degrees, irrespective of whether their role at the community legal centre was as a lawyer or in some other role. So the first question, did it prepare you? Yes or no, but it was graded into not at all or it completely did. So 293 people completed that question. And then we had two open-ended questions about what was it that prepared them and what needed to change. Another law school. So just briefly, we'll look at the characteristics of the people that responded to these questions. So like the rest of the workforce in the community legal centres, the workforce is actually fairly young and mostly female. As you can see, 75% are women. Now, I've just got another note from someone that my audio is a bit scratchy. So I think I'll just try and see if I can do something about that, but I'm not quite sure what it could be. I'll just increase that. Hopefully that works a little bit better. It might be the internet out here at the moment. Better. Okay, great. Thank you. So we basically asked those with law degrees where they studied law. And 75% said that they studied law at a Victorian university. 24% had completed their law degrees interstate, and 1.3% had completed it overseas. The most common law schools for the CLC workforce were Monash, Melbourne, Deakin and La Trobe, basically the biggest universities in Victoria. And people who studied law most commonly also studied arts and humanities, 54% of our sample. Smaller proportions of people that also studied business and management, about 9%, psychology, about 5%, and about 4% had also said they studied social and public policy. So there was certainly a strong arts and humanities focus. So nearly 53% of our respondents had a current unsupervised legal practicing certificate, and nearly 1 in 5 people actually have a law degree, but they don't practice. So, for example, they might be working in a community legal centre, either in management or centre operations. They weren't excluded from this component of the survey. So of current certificate holders, which was about 292, they had been certified for a median of 7 years. And let's go to some of the findings, looking at the first question, again in the background, another law school in Victoria. So about half said yes and a half said no. So when we asked them, did your law degree prepare you for work in the community legal sector? 46% said entirely or mostly. And 54% said not really or not at all. So we asked ourselves, is this because of the university that they went to, or is it because of the CLC that they work at? Was it their gender, their age, whether their legal centre was rural-based or not? So what we then did was to look at the impact of these variables using a specific statistical analysis called a cross-classified model. Basically, we wanted to see if usefulness of their law degree was influenced by their law school and CLC, and trying to control for all of those other factors. So this is looking very complicated, but in this analysis, we used law school and CLC as random effect variables. So the specific model fitted was a cross-classified model, as I mentioned. So that allowed us to explore whether the usefulness of law degrees varied significantly by university or their law school and the community legal centre that they worked at. So this type of model was required since respondents both belong to a law school and a community legal centre. So this type of analysis actually comes from school attainment data, where statisticians were trying to figure out whether school achievement, the differences in how students achieved, how well they did at school, and they tried to control for basically the type of school that they went to and the area in which the school that they were in. So here you can see in this analysis, you can belong to both a university or a CLC. But because we don't have enough data for each group, this analysis, doing all its magic behind the scenes, allows you to treat the CLC and university as random variables. That is, if there's a variation between law school and whether people rated the degree of useful or not, was that variation real or was it just random? And if it was random, then we can conclude that the law school had no effect. And similarly for CLCs. So these are the variables that we put into the model. So the outcome variable was whether people saw their law degree as something that prepared them for CLC work or not. The random effect variables were law school and community legal centre, and the fixed effects are basically things that generally kind of can't change, like sex or gender. And so you see these are the variables 3 to 9. So what did we find? We had our hunches. We thought, oh, maybe it's people who've studied arts and humanities, or maybe it's people who've been practicing longer, kind of saw it as more or less useful. We actually found that there was no main effect of law school or CLC, no one university or group that popped out as having an impact, or the CLC that they worked at. But what we did find was a significant effect of age and gender. So older respondents appeared to view law degrees as more useful, particularly for those aged 60 or older. And male respondents were also significantly more likely than female respondents to perceive their law degrees as useful. Now, we might have a few hunches as to why that is, but fundamentally, the findings aren't patterned by university, CLC, or respondent. So it had no impact in terms of whether they felt they were prepared or not. So is it because these people are looking back on their law degrees with rose-coloured glasses, or is there something else going on? So something's telling us that is perhaps a bit less about choice, and more about chance. And I guess this is where our qualitative data comes in. So some of the qualitative data that we found was we asked them if they, just as a refresher, if they did find that it prepared them, we asked them what bits worked. And if they said that it didn't, we asked them what needed to change. So we'll first turn to what they found useful. And there were 4 main themes, and they were around the obvious things: gaining legal knowledge, gaining legal skills, the importance of real-world experience, clinical placements, and actually being inspired by lecturers and being inspired in the issues around social justice. So on these slides, I've presented some quotes from the survey. I'm not going to read the quotes out, but you can read those instead of listening to me. So generally, they said, it was great because I gained a broad legal knowledge. So some subjects were highly relevant to community legal work, such as family law, human rights law, and dispute resolution. And this was also true for those who didn't work in legal roles, as you can see here by these quotes. They said that they gained the legal skills that they needed. And there were specific legal skills that they gained that were relevant for the CLC context, such as research skills, being able to find relevant legislation, problem-solving skills, and being able to deal with complexity. A large number of respondents emphasised that their work experience or clinical placement undertaken during their studies as important, and noted how this helped prepare them for the realities of CLC work. This makes complete sense. Respondents often felt strongly about how important and useful the opportunity to undertake practical experience at university had been, with many voicing support for practical training and that it should actually be a compulsory degree requirement. For a number of individuals, they noted how their degree and specifics of their program actually sparked their interest in social justice. So it indicates that people aren't going in there going, oh, I'm going to work at a CLC, but something triggers it while they're doing their program. And so for some, this helped because their degree is focused on social justice, and for others, it was individual members of the university staff that imparted these social justice values, but also let them know about how CLCs could provide them with practical avenues to pursue these interests. So it was lucky for them, but what about those who did not have, the luck of an inspiring lecturer? And, how do we expose more people and give them the chance of being inspired by working in this sector? So for those, conversely, for those who said their degree did not prepare them, there were 6 main themes. And you'll see in these themes, there's actually a bit of an overlap. It's kind of like the opposite of what was said was good. And these ones are saying, oh, this was actually bad. So they thought that the law degrees needed to broaden their focus. There was a mismatch between legal matters discussed in degree programs and what it's actually like in the real world. For example, they were highly unlikely to be dealing with high court matters. Some respondents were even more brutal and wanted the priestly 11 legal subjects abolished. They said that law schools missed out on teaching about holistic lawyering, about community development and partnership building. Many complained that law schools focused on the work of private and commercial law firms rather than public interest lawyering. Success in law meant working at a top-tier firm. That was the message. And so much so that they barely knew about or heard about community legal centres and the work that they did. The focus was on teaching black letter law with no social context to the law or how it actually functions in the real world and what the community needs, for example, to be able to access the law. They also noted that there was a need for a better understanding of trauma-informed practice, social work, financial counselling. Understanding these principles was seen as important, so a greater breadth in subjects or electives was called for. They also felt that the focus of law schools was seen as very narrow and privileged and disconnected from the community. There was a lack of attention to practical legal skills, like filling out a form to submit an application to BCAT, for example. And even though they said that they learnt these skills post-graduation as part of the practical legal training requirements, many thought that an early introduction would be beneficial. A number of respondents felt that practical skill training should more strongly focus on developing and understanding how to work with clients, and in particular disadvantaged clients, so not just the tin tacks of everyday legal work. For many, this was seen as a key deficiency of university legal education. Universities taught little about clients and, more importantly, for community legal work, providing legal services to different cohorts of clients, such as those from culturally diverse backgrounds, traumatised clients, and those with complex overlapping legal and other needs. Who's calling me on my home phone? Okay, that's it. And then there were the practical realities of working in community law, not just the complexity of clients, as we noted, but also the complexity of the system in which they are working. They need to know about multidisciplinary practice, working with stakeholders, and navigating other service systems such as health and social security. They do not work in a silo. Then there was the issue and problem with funding, and namely how under-resourced the sector is. And this was certainly something that respondents let us know about in other sections of the survey, that people outside the sector would actually fail to appreciate this fact, that they were able to achieve so much with so little. And several respondents stated that public universities had a duty to support public access to justice. There was limited awareness raising about CLCs and the placements and volunteer opportunities that they provide. The focus was primarily on private law firms. But for CLCs, resourcing is also needed. They can't do the university's work basically for free. And on this issue, I've included a quote from the CEO survey. There was a strong feeling among some respondents that universities often extracted greater value from community legal centre placements than centres themselves. And for some centres, they were simply not funded or staffed to provide training, given that their resources were so stretched. And so, like many other aspects of community legal centre work, student placements and volunteers raised for them a funding issue. So the future. So the main issues I think that I've touched on here in relation to legal education and community lawyering is about fostering the understanding of community law, for example, law subject breadth, inspiring an interest in social justice, developing practical legal skills, and encouraging working with real people with real problems. But we can ask ourselves, can or should a law degree be all things to all people? And placements, how do we fit those things, that aspect in? And what resourcing is needed for CLCs in the future? Here are the quiz answers, but there's actually no prize. I don't know if you picked them all, because since I went to university, a lot of these law schools actually changed. But I'll now hand over to Louisa, who will continue the presentation. Thank you.
Thanks so much, Jessica. And thanks so much to everyone for this opportunity to share with you today at the conference. My name is Louise Gibbs and I'm the current CEO of the Federation of Community Legal Centres in Victoria. So we are the state's peak body for community legal centres and Aboriginal legal services. And mine is an absolutely fascinating and rewarding job. And today I'm speaking to you from my home, and it stands on Wurundjeri land, and I know it always will. I pay my respects to elders past, present and emerging, and acknowledge their strong legal traditions and that sovereignty was never ceded. I also pay my respects to any First Nations people who join us on the call today. Now, it's been an absolute pleasure working with Josica and the team at the Victoria Law Foundation on the Community Legal Centre Workforce Survey project. The findings are helping us to develop a 10-year sector plan with a focus on sustainability and innovation. So the role of universities and legal education are central to that sustainability. But before I talk about how we'll be using the workforce survey into the future, I would like to take you on a little journey into the past, and specifically to the students of Monash University back in the 1970s. Now, I'm happy to say that Victorians were early movers and shakers in the movement to provide free community-led advice and legal services. And at the forefront were a small group of Monash University students and academics. In around 1971, they opened a small telephone advice line. And from little things, big things grow. And what I can tell you is that last year, the two community legal centres that have sprung from that exercise, which is Monash Law Clinics and South East Monash Legal Services, reported serving an incredible 7,862 clients. Now, around the same time, Fitzroy Legal Service opened its doors in the basement of the Fitzroy Town Hall, and it did the unthinkable. It provided free legal advice to everyone, to all people, in one of the poorest suburbs of Melbourne. And we have a fabulous photo of these early community lawyers, which I'm just going to share with you now. So here we are with the Fitzroy Legal Service. 1973 also saw the establishment of the Victorian Aboriginal Legal Service as a community-controlled cooperative society. And since that day, VALS has played a unique and essential role in providing quality and culturally appropriate referrals, advice and representation for Aboriginal Australians. Now, for my own part, earlier in my career, I spent 4 years as the Principal Solicitor at North Melbourne Legal Service, which is now called Inner Melbourne Community Legal. And I'm just going to do a little shout out because I can see from the participants list that Richard's on the call, Richard Stewart, and he was another former Principal Solicitor there. North Melbourne started in 1978. At first, volunteers operated out of the Uniting Church Hall with a homemade neon sign to attract clients. It then graduated to its very own office, affectionately known as the Broom Cupboard because that's how big it was. The Honourable Justice Peter Armand was a graduate lawyer at the time. He and a group of other friends recognised the need for an accessible community service in the North Melbourne Flemington area, as people were travelling across to Fitzroy to access such services. Justice Armand has explained, there are a lot of single parents and people didn't necessarily have cars. While getting from Flemington and North Melbourne to Fitzroy may not sound difficult, it was for many. We had this idea to take the legal service to the community rather than the community to the legal service. And bringing the legal service to the community has been the story ever since. There are now 47 community legal centres across Victoria. And this includes 22 place-based services, which understand intimately and respond to the specific legal needs of their geographic communities. And our membership also includes 25 specialist services, responding to a vast array of legal needs, from tenancy to employment to social security, and also for different client communities, such as asylum seekers, recent migrants, women, people with disabilities, young people and seniors, and then also specifically on some topics like the environment and animal rights. Okay. Now, if we ask the question about whether law degrees prepare students for a career in community lawyering, it's a good idea to reflect on the areas of law that are commonly dealt with in community legal centres. Sector-wide data tells us that the main areas of advice and representation by community legal centres are tenancy, family law and family violence, social security, employment, consumer affairs. What if we had to compare those practice areas with the subjects that students study as part of their law degrees? Are the students developing the skills they need in those technical areas? And now, whilst Josica is the researcher here and she has conducted the workforce survey with exacting standards of statistical analysis, for this particular exercise, I'm going to be relying on a sample size of 1, myself, to ruminate on whether law subjects are a sound foundation for a career as a community lawyer. So here I'm going to share with you my academic transcript. I've highlighted the law subjects that I studied in pink. Now, happily, you'll see that in 1994, I studied contract law, and then in 1997, I studied family law. In 1996, I just scraped through civil procedure as well. And these subjects have absolutely been foundational subjects for my time as a solicitor in a community legal centre. But apart from those subjects, everything I know about tenancy, family law and family violence, employment, social security and consumer affairs, I've learned on the job. And whilst you might be reassured to know that I know how to arrest a ship from my study of maritime law in 1998, and also the origin of many legal words from my study of Roman law in 1996, I do have to concede that in my career, there has not been a great call for these particular skills. Now, admittedly, there was a much wider range of legal subjects on offer than the ones that I chose to study. But as someone who has a deep passion for social justice and has chosen to make a career in the community legal sector, it is interesting to reflect that I haven't lent heavily on the degree itself. Rather, I would credit the experienced volunteer lawyers at the evening service at the Coburg Brunswick Legal Service in the early 2000s, who took me under their wing once a week. They taught me the fundamental laws, legal strategies, and client service techniques that I've needed to be an effective community lawyer. So looking at my transcript, you'll also see that I studied advocacy in 1998. Of all my subjects, this was the only one that had a practical application, and the marks here were awarded on the basis of a performance in a mock trial. So this makes me reflect on the fact that the majority of our law degrees are focused on the academic aspect of legal practice. Now, in many contexts, legal technical expertise is absolutely sufficient to be an effective practitioner and will result in quality service to a client. However, the story is a bit different for community lawyers. Community lawyers are on a journey with their clients, and those clients are frequently marginalised and may have complex, intersecting legal, social and health issues. Technical legal skills are essential, but they're certainly not sufficient for this type of practice. So to give you a sense of the intersecting and compounding issues that community legal centre clients are living with, data from 31 CLCs last financial year showed us that 3 out of 4 were experiencing financial difficulty. 7 out of 10 were survivors of family violence. 1 out of 4 identified as having a disability, and at least 1 in 5 had a mental ill health condition. And this rate rose to 3 out of 5 for clients who presented with 6 or more legal issues. So lawyers who are effective in serving these types of clients take a trauma-informed approach to their work. They have skills in explaining complex legal concepts in plain English. They adjust their own style depending on the client, recognising when extra supports, such as an interpreter or a social worker, are needed. And they are collaborators working in tandem with representatives from other community organisations like financial counsellors, health clinics, housing providers and counsellors to ensure that the client is at the centre of the legal service being provided. Now, the Federation runs a program of training every year for its community lawyers, and I can tell you that the topic called Working with Difficult Clients is sold out every time we offer the session. Now, I have a fun fact. Did you know that evidence shows people are more likely to tell their GP or another frontline social service about their legal problem than a lawyer? Because of this, community legal centres have established strong integrated service partnerships in their communities to ensure that lawyers are in the place where people are sharing and that they have a legal problem. Skills in forming strong partnerships to take the law to the community, just as Justice Armand realised way back in 1978, are central to effective provision of legal services for the most marginalised and disadvantaged in our communities. Now, one of the most enjoyable parts of being a community lawyer is also transforming the lived experiences of your clients into advocacy for systemic change. Now, most community legal centres not only provide legal advice and representation for clients, they also play an active role in law reform. And this can range from formal submissions to government government inquiries, through to meeting with parliamentarians, like the one you can see here recently when I met with Senators Lydia Thorpe and Janet Rice, through to public campaigns to raise attention to the issue. So I've been in the job 3 months, and these were just some of the photos I could draw together of that advocacy work I've already had the opportunity to be part of. It's fantastic, life-changing, systemic work. So some law students study double degrees that help them to develop skills in this area. Subjects such as political science, public policy or marketing, social work or community development are great complementary skills to a law degree. Community lawyers are all about taking an holistic approach. So perhaps one idea in the future is to look at those opportunities that arrive from a constructive conversation between the law faculty and other faculties of a university. Clinical programs that Josica mentioned also go some way to providing opportunities for students to develop appropriate client service skills, and students gain credits for undertaking these subjects, which is fantastic. Interestingly, though, the workforce survey did not find any statistically significant variation across centres or across universities, and that's with those that do and don't offer clinical programs. So in the probability of law degrees being perceived as being useful. So whilst the feedback from CLC staff in Josica's research shows this can sometimes be burdensome, on the whole, CLCs welcome contributions by students and are proud to help them develop skills that are essential to being an effective practitioner in the community legal centre. Now, what we also know is that the desire of law students to make a career as a community lawyer is strong. In 2012, the Law Institute of Victoria undertook a study into attracting graduate lawyers into the sector. It found that 20% of the 300 law students that they interviewed wanted to undertake a graduate traineeship in a community legal centre. Whether or not their law degrees prepare them for it, law students are keen to be part of the interesting and rewarding work in the community legal sector. So looking ahead, how will community legal centres use the findings from this report? What the research tells us is that most community lawyers do not think their law degree prepared them for the work that they do now. So this certainly helps us to focus our conversations with universities about course content that is supportive of community lawyering to promote a sustainable and thriving community legal sector into the future. But I want to pause here for a minute too, because we should also recognise that nearly half of our community lawyers said that their law degree did prepare them for their careers. So the successes in law degree curriculums should be celebrated, and we need to build on those strengths. The research also helps us to think more broadly about how we need to be promoting a career in community law with students whilst they are studying their degrees and with the academics who teach them. And the final message I wanted to share with you today is to acknowledge the amazing role that volunteers play in community legal centres. 4,000 Victorians, 4,000 work at community legal centres, with more than half of that number being volunteers. This includes the law students who give their time and talents to support access to justice for their fellow Victorians whilst they are studying. Those of us who work full-time at community legal centres, we love what we do. And the workforce survey found that 83% of us say that we were drawn to this work because we want to help people. So for everyone attending today who is or has volunteered with the Community Legal Centre, be proud that you are part of a movement for social change that has been changing lives for nearly half a century. Together, we are making our community that is fair, inclusive and thriving, where every person belongs and can learn, grow, heal, participate and be heard. And that's something pretty special to be part of. Thank you. I'm going to pass now to Genevieve.
Thanks, Louisa. I'll share my screen here. Good. Great. There we are. I think that's worked. All right, good. Well, thanks so much, firstly, to Josica and the VLF and Louisa for including me today. I'm speaking from the perspective of an Australian legal academic who's been teaching and researching in law schools for horrifyingly now about the last 12 years. And at Monash, I principally teach litigation and dispute resolution, so what used to be civil procedure, but also spend some time teaching legal ethics and company law as well. All the fun stuff. I'm not even joking. I really believe that. What I don't do, though, is teach in Monash's clinical program. So I'm not speaking from the point of view of the clinical program at Monash, which is a really big part of what we do, but rather from the point of view of an academic involved in the delivery of these core units, I guess. And I guess just to echo some of what Louise has said about her own experience of legal education. I mean, I know that when I studied civil procedure as an undergraduate law student, we basically worked through the rules from top to bottom, and that was civil procedure. So it's no surprise that that Louisa perhaps didn't appeal to you at that time. I think since then it really has been transformed, so that now in our unit, students get a role-playing experience of online dispute resolution, of negotiation and mediation. We experiment with online court forms and those sorts of things. So it really is a different approach. And I guess I wanted to mention that because, like a lot of the others in the webinar today, I describe the way that I teach as being very much about a law in context approach. I like nothing more than talking about the Law Australia-wide survey evidence about people's experience of legal problems to give students context about how few proceedings actually end up being litigated in court, or how few disputes. And I also like to emphasise the fact that the most common type of civil litigation we have in Victoria is, of course, an undefended debt claim in the magistrate's court. It's really important to provide that kind of context. And I think that's probably really consistent as well with the focus of the Law and Society Association of Australia and New Zealand as well. So, having provided that background, what I'd like to do is respond to Josica's findings and Louisa's contribution in a few ways. I'd like to talk about a couple of key points, really. I mean, just to endorse some of what Louisa has said about community lawyering and legal education in Australia, and to really acknowledge that history, particularly for Monash. It's a really extensive history of a long relationship that I think it's important to acknowledge. I want to talk about the value of the data that's come out of the CLC workforce survey, because it's such an important piece of information for law schools as well as for CLCs in thinking about how we do what we do and what it is that we're achieving. I'm going to be cheeky though and say I think there's even more data that we need about graduate destinations to really properly understand what it is that law schools are doing to support the various kinds of pathways that students might go on. So, it's always the way. Researchers want more data, but it's certainly the case here too. I want to touch on the kind of the very well-established debates about the nature and purpose and focus of legal education, and to think about how this evidence about CLC workforce issues connects with those debates. And also the regulation of law schools. And I say this, it's hard not to sound offensive, but, in some ways I would like nothing more than, as some of the survey respondents said, to throw out the Priestley 11 and to start again, and to embark on some kind of a co-design approach to legal education would be terrific. But we are really constrained by the regulatory environment that we operate in. So I'm going to say a couple of things about that. And then also to comment on some of the options that might exist for addressing the sorts of needs that have been articulated in the survey evidence. And then finally to finish off with something that I wrestle with, which is about how responsive legal education should be to the needs of the profession, whether it's coming from a CLC perspective or from a commercial law perspective, and the kind of the controversy that goes with that. So to start with, I got a couple of photos here too that I really like this one. I like any photo with a phone number that has fewer digits than we have now, because it just underscores how old it is. This photo, I understand, is from some of those early days at Monash in the late 1970s, I think, this photo. But this long relationship that I mentioned between community law and legal education in Australia is a really important part of the Monash story, as it is for a number of universities. Monash is proud to be home to Australia's oldest university-based legal clinic. And I think the sort of the social justice and clinical opportunity focus that we have is really a core part of, as I say, what we do. And as I've said, elsewhere in other universities too. So I just wanted to acknowledge that, I guess, and to provide you with a couple of updated pictures about what the clinics look like now. In terms of graduate destinations, sometimes we talk about a data gap, especially in and around civil justice and legal services, but this one's much more of a data abyss. I've kind of been really interested for a long time about why law schools don't do a better job of tracking graduate outcomes. And, whenever I've asked, people have sort of suggested, well, it's because it's very difficult to measure rather where law graduates end up, because sometimes it takes a long time for them to qualify. Maybe they have a break before they get admitted, all of these reasons that really seem quite self-serving about why we don't have a great picture about the various pathways that our students sort of take post their law degree. And I think in that context, this workforce survey evidence is really valuable, because it does tell us something about people who've entered practice. From Josica's data, really these are people who are typically quite well established in practice. I mean, I think she mentioned 7 years with a practicing certificate as being the median. And so it's really valuable information to have about whether people feel as though their legal education has prepared them for their work. So I'll come back to some of that data, but as I mentioned, just from a data greedy kind of a point of view, we do have this kind of striking lack of data about the various pathways that our graduates take, and the sorts of things that I think we need more information on to really help us be better informed or make decisions about course content and how it relates to graduate pathways is, what proportion of our graduates really do end up in practice, what kind of practice and over what timelines, and what sort of non-practicing careers our graduates engage in. I know that Monash and elsewhere, there's this kind of rule of thumb that about 50% of our graduates will end up in legal practice. That seems to be what people say now. I can't find where that comes from. There's the odd media report, but it's certainly the case that there's a significant proportion of our graduates who end up in non-practicing careers. But I think having better information about that would put us in a stronger sort of a footing for shaping our ideas about content and focus for legal education. I did come across one piece of evidence though, which was this graduate tracking survey from 2017. Some of you may have seen this before. I found it buried in the papers of a Council of Australian Law Deans meetings. I'm not even sure whether it's on the internet, but I don't know how public this information is. But it seems as though in 2017, the New South Wales Law Society embarked on what was meant to be a longitudinal study of graduate destinations with what they called a benchmark survey, where they managed to get nearly 1,000 respondents, final year law students in New South Wales and the ACT to respond to a survey about their practicing intentions post the completion of their degree. And what they found was that nearly 2/3 intended to practice, with 35% unsure or not wanting to practice. Amongst those who did indicate they had a preference for practice, we can see the community legal service there was at about 8% of those who had a practicing intention, and amongst those with who articulated a non-practicing career preference, that government and policy work, banking and finance, and international development were amongst the biggest chunks of where people hoped to end up. As far as I can tell, I mean, I'm guessing that COVID put a stop to attempts to continue on with this work, because their stated intention was to do this baseline work and then to follow up with graduates 2 or 3 years and then 5 or 6 years out from this baseline. But have never been heard of again, as far as I can see. So that seems to be a shame. It would be great information to have. So just to add to that, I mean, the long history of debates about legal education, I think, are worth mentioning here. You know, this is territory that will be well known to all of us, I'm sure, that there are these persistent questions that have always been about what it is that law schools are preparing graduates for, whether it is about preparing junior practitioners, whether it's about making sure that people are equipped with the job-ready skills that they need to embark on a legal practicing career, whether instead perhaps it's more about engendering critical thinking skills, research skills, social justice values as well, and what the balance might be between those objectives. Interestingly, the most recent debates about legal education and what we need to do better have really focused on the role of technology and preparing junior practitioners for the realities of sort of 21st century legal practice. Whereas the sorts of things that have been articulated in the CLC workforce survey have been long-standing suggestions that don't seem to have been well enough embraced by universities, about things like engagement with problem-solving approaches, multidisciplinary practice, collaboration with social work and other types of professional services, more trauma-informed approaches. There's plenty of legal scholarship writing about the need for these types of approaches to be incorporated into legal education, but striking that the current crop of practitioners in CLCs don't feel that they've had that exposure. So just interesting to I guess for those of us who are in legal education, to take note that it's easy to get captivated by the focus on technology as being what we should all be obsessed with at the moment, which is predominantly, I think, a commercially driven type of a focus, whereas these realities about needing to work with other practitioners in order to serve the needs of clients people might have, don't seem to be as well addressed by the dominant debate at the moment. The other thing I wanted to mention too was, and this goes back to not wanting to sound too defensive, but the real need to think about legal education as being part of developing lawyers, and a trajectory through education in law schools, practical legal training, the requirements around admission to practice and what people need to demonstrate in order to get admitted, the regulation of lawyers as competent practitioners and continuing professional development and the professional learning that happens. And of course, the difficulty is here that these elements of lawyer development are regulated by different entities and delivered by different parts of the legal and professional development landscape, if you like. And it's interesting to see that both Sally Kift, a really noted legal education expert in Australia, and Jordan Furlong, who's written about similar issues in the US context, have talked about the need to sort of stop compartmentalizing the way that lawyers are developed, and rather to think about this as a sort of a single continuum, and that involves really thinking more extended. So I think what Louisa mentioned about the dialogue that's going to perhaps open up even more between universities and the CLC sector is a reflection of that. I mean, it's about what is it that that universities can do to perhaps help practitioners in the CLC context, and what other sources of support or development might be available as well. So I can't talk about the way that my defensive body language. Oh, it's really ramping up. I can't talk about the way that universities prepare lawyers without talking about the academic requirements for admission, and the connection between the Priestley 11, these prescribed areas of knowledge, and threshold learning outcomes as well. This kind of other critical part of what universities need to be attentive to in the design and delivery of legal education. Sally Kift again has described what's involved here as being this kind of gestalt of knowledge, skills and values, and that these academic requirements, these Priestley 11 units are only one part of the threshold learning outcomes that universities are so focused on. Other commentators have really pointed to the fact that this Priestley 11 list is evidence of legal education being captured by the profession and its obsession with content. I think there's also something in that. But it is certainly the case that there's an inherent conservatism in the regulation of the content that law schools deliver, and the pace of change is slow. I can certainly say, from the point of view of litigation and dispute resolution teaching, the move from civil procedure to what's described now as a civil dispute resolution area of knowledge, that was a long process. It took a long time to convince the regulator of these prescribed areas of knowledge that, in fact, appropriate dispute resolution should be a required component of our teaching of civil dispute resolution, rather than just interrogatories and pleadings or something of that nature. And I'm sure there's plenty of you on the webinar who are aware that there is a current, there was to be a revised description of these prescribed areas of knowledge for university units that was to come into force from the 1st of January this year, and inexplicably that didn't happen. And the consultation that went on to modernise these prescribed areas of knowledge seems to have been put on hold indefinitely. So we await news on that. But it's certainly the case that that universities, to maintain the ability of graduates to get admitted, are beholden to these prescribed areas of knowledge. And I want to take that sort of discussion a little further in thinking about, well, why don't we just chuck the Priestley 11 out the window? And some of you might know Olivia Rundle at the University of Tasmania, who wrote really persuasively about these things in the Australian Law Journal a couple of years ago with her colleague Lyndon Griggs, where she referred to this idea that law schools are drowning in bureaucracy. There are multiple bodies that are involved in the accreditation and regulation and monitoring of what's in our law courses and how we deliver legal education. And these are bodies that operate across at a national level, a state and territory level as well, often with competing objectives and with multiple layers of regulation. And this snapshot here of the regulation of law schools was just designed to kind of capture that, so you can kind of see what we're up against when we try to modernise and address the interests of organisations like CLCs. These include things like the Law Admissions Consultative Committee, those prescribed areas of knowledge, the reporting that has to be done internally to universities, but also the requirements of admitting authorities too, who provide universities with the accreditation they need to be able to get students admitted to practice. So the regulatory burden here is pretty significant. So I wanted to say a few things now about addressing the needs that are articulated in the workforce survey evidence, and thinking about what the options might be. As I know, most universities have done. In the last 3 years, Monash has taken really significant steps to try and address questions around graduate employability and the sorts of skills that were referred to in the survey evidence are part and parcel of that. We actually have a clinical guarantee now, which since 2018 has meant that any Monash law student who wants a clinical experience is able to get that. Just to respond also to the concern about the burden on CLCs of some of these clinical programs, I just want to show you quickly. This is a snapshot of some of the in-house clinics and the specialist clinics that Monash now runs, that include things like a law reform clinic. There are a range of advocacy clinics, some of which deal specifically with the kind of community health settings that Louisa was referring to, and social security rights. Also a lot of clinics focused on technology and human rights as well. So we're moving beyond just burdening CLCs with our students. But also, I think there are tensions we need to talk about here, because in order to provide some of the technical content that CLCs might be interested in, we'd have to make trade-offs about what we would take out of what's a pretty jam-packed curriculum. And I wonder whether there might be tensions between the calls for more technical content to come in and the parallel call being made in the workforce survey evidence for more access to justice framing. You know, it's difficult to engage in some of the more contextual scene setting work if what you're doing is kind of just delivering more content all the time. So there are other ways we can think about addressing some of the needs that have been articulated. I mean, I think emphasising the law in context approach through our teaching is often a sort of a successful way to think about access to justice. So building content into our existing units, you know, and that seems to be much of what's happening in universities at the moment, not least as a product of the pandemic. You know, I mean, I personally haven't taught face-to-face in a classroom for 2 years, unbelievably. And that's given me lots of time after I've recovered from the exhaustion to think about how we could do, how I could deliver my classes differently. But a broader range of clinical opportunities is certainly part of the discussion at Monash. I'm not convinced that greater specialisation, you know, in the mode of an engineering degree is really a feasible option. You know, I don't think students enter law school with a vision to become a community lawyer necessarily in a way where we could set them on a community lawyering path or a commercial law path or something of that kind. So I think that sort of hyper specialisation is probably not the way to go. But I think it's also important to acknowledge that there are other skills not referred to in the workforce survey evidence that are nonetheless important and valuable in a CLCC setting that we could think about universities also delivering. So Louisa mentioned the law reform and advocacy work that CLCs do. The VLF has a terrific knowledge grants program that supports CLCs to build capacity in research and the use of their own data. You know, I mean, we're currently working with South East Monash Legal Service to look at evidence about wage theft claims and how those are dealt with by that service using the administrative data that they've collected. And I think that sort of work really emphasises evaluation and data analysis as being important skills in a CLC setting too. So I guess there are choices we have to make about what we can fit in and what we might take out and what we can take out as a consequence. And I just wanted to finish by saying something perhaps a little bit more controversial, which was about a kind of not a concern, but a kind of a thought I've had for a long time about how responsive law schools really should be to practitioner interests in terms of reform and development of legal education. And this is in the context of practicing pathways accounting for a smaller share of our graduate destinations, you know, and what that means in terms of the implications. And I've put here a slightly inflammatory question about whether CLC perspectives should be treated differently to commercial law firm perspectives. I think my feeling is that that they should, you know, I think not least because of the special relationship between CLCs and universities in Australia, and especially Monash. I think the evidence in the workforce survey about the resource constraints in CLCs is obviously really compelling. And so there is certainly a need to be aware that that universities have a role to play in potentially supporting CLCs and the development of their staff. I'm less sympathetic to the commercial law firms who like to come along to law school planning days and tell us that we need to be teaching graduates who end up in private practice project management and design thinking skills. I kind of think they can pay for that. But in the context of thinking about a sustainable relationship between CLCs and universities, it feels like there's something, certainly something in that. And so I'm glad that this workforce survey evidence will provide an evidence base for stimulating those discussions. So that's all I had to say. And I wonder whether we might have some questions, Lynn.
We certainly do have questions, Genevieve. We've got lots. I've got lots. So if you would like to keep me quiet and get your question in, then please put it in the Q&A function now, and we'll work our way through them. But, absolutely riveting presentations from all three of you. So thank you very much indeed for exploring the different dimensions. of legal education and the data that we've uncovered. Giles, there are a few questions that go directly to some of the findings in the research. So perhaps we can pick those off first and then move to the questions that go more, I suppose, to the analysis. But there was a question about the ways or the aspects of the degree courses that people found useful. Was there, or did you have a ranking of which ones or which parts of the degree people found most useful?
Yeah, I think that because it was qualitative data, right, so people had to come up with their ideas on the spot. We didn't prompt them with a list of answers that could be relevant. And but yeah, there were definitely standouts, and they were the same standouts for what was useful as for those what was lacking. And that was about those practical skills, right? So the people that said their law degree was useful said, yeah, I learned all these practical skills that I'm using in my community lawyering. And also about the legal areas that they learned, and in particular their placements, right? So when we looked at people who said what was missing or what needs to change, right? So like the top two were about offering law subjects that focus on community legal centre areas of law, right? Those having a greater breadth. That was the one of the most popular, and the other most popular was learning how to work with real clients.
Okay, so I think that goes to the second question, which is around soft skills and whether or not research threw up any pointers in that direction. So I suppose if you're saying that, you know, one of the key responses was around dealing with clients, then that would capture soft skills to an extent too.
Yeah. So obviously, again, we didn't specifically target what soft skills did you need to learn, but they mentioned those things like communication skills, networking skills, being empathetic and understanding, you know, client perspective, trauma-informed care and those kinds of things, and the research skills and other skills that they mentioned that don't kind of come as an obvious skill that you might learn through your law degree.
Yes, absolutely. And we'll come to that tension that Genevieve put so well a little later around, I suppose, the sort of intellectual basis of legal study and then the skill development and where that sits in terms of that continuum of legal training and education over a lifetime or a career path. But speaking of career paths, Louisa, there's an interesting question here about whether or not CLCs provide opportunities for career development within, I imagine the questioner is asking, within the CLC itself, and that may have been a reason, in Trisha's experience at least, that people left the CLC sector. Has that changed?
I saw that question, and it's an excellent question. There's a few ways to approach this. CLC, we're really trying to promote within the sector, now that we have such a big workforce, that careers can happen across CLCs. So you might start in one CLC and then take those skills to a more senior role or a parallel role in another CLC. So the career paths can keep your interest and your skills in the sector. One huge challenge we face, though, is that whilst there's pretty good pay parity at the junior levels between community legal centres and Victoria Legal Aid and government roles. Once you get up the ranks, community legal centres unfortunately can't match the pay that are provided through those government organisations. So what we find is career sometimes is not so much about a desire to leave the sector to go to a different place. They'd love to stay in the sector, but the career progression takes them elsewhere because of the pay. So that's a tension that we have within the sector as well. So we've done a lot of work trying to make sure that people are really aware of jobs available in the sector and can move within the sector into more interesting and rewarding jobs in other CLCs from the one that they were working with.
How can you address that issue around pay parity at higher levels? You know, I mean, we all are keenly aware of the financial constraints on CLCs as just a, you know, an ongoing dilemma. But given the parity at lower ranks, what's the problem at matching it higher up?
So it is a funding problem. It's about how government awards have been negotiated versus what the community sector awards have been negotiated. And we fall under the community sector, the SHADS award, which is a community-based award rather than a public service award. And so I think it's about, there's a lot of advocacy goes on in that space. And it's doing the most with what we have. That's why volunteers are so important in the space as well, because with a small amount of money, but more people, you can achieve more client outcomes as well. Lots of challenges there, and it's something that the Federation and community legal centres work on together to try and find some options, but it's really about raising the funding for community legal centres generally in order for those pays to be offered.
I mean, this goes to a profound philosophical challenge around the provision of legal service and whether or not it should be so reliant on 4,000 outstanding volunteers, but that's perhaps a question for another day. Let's go to Richard Stewart's question around, I think this refers to clinical placements, and he was involved with the development of the unit at RMIT, which is apparently now discontinued. But the question is around whether or not the impact of those clinical placement units was explored at any length in the survey. Jos, did it?
Yeah, we didn't ask specifically, as part of your legal education, did you participate in a clinical placement or program? And that did come out in, I guess, the qualitative answers where they said, well, I did a clinical placement and therefore I learned X, Y, and Z. So we would need to go back to, quantify that and then perhaps differentiate between those kind of responses, but we didn't ask it specifically, no.
Jen, have you got any insight into, I suppose, the value that graduates put on the clinical placement experience? Do you get any sense, for example, that people come to Monash because that's an opportunity that you offer?
Yeah, I mean, I think that's true. I mean, it's a competitive market for employment, obviously, intensely for law graduates, and so any kind of practical experience is a real benefit. I also know, though, that it's kind of well established that at Monash, amongst alumni, a clinical experience is a really important factor, and it's something people talk about for a long time. I think it really shapes people's career trajectory and thinking about what sort of work they'd like to do. So, even beyond the kind of the preparation for or development of skills for a CLC setting, it's also sort of significant in that vein of kind of opening people's eyes to possibilities and how rewarding that kind of work can be in terms of what it involves. So it's it certainly is a really significant part of the landscape at Monash.
I mean, it's a competitive environment not only for employment, but also for law schools. I mean, we've got 9 in Victoria, so that's a spread of options in terms of the destination for your potential law student. But is there much differentiation or much emphasis that you can see in terms of the way in which law schools might present themselves and their relative foregrounding of sort of community lawyering type offer?
Yeah, I mean, it certainly features very prominently in Monash's marketing, which I try not to pay a huge amount of attention to because I'm not the target demographic. But yeah, I think it is something university is proud of, and they really do. They do promote really significantly.
There's another great question from Esther around trauma-informed practice and trauma-informed approach to legal practice. Which I might start with you, Jen, about this, and then maybe to Louisa as well, because as Louisa pointed out, the opportunities in CLC land are diverse, and where you might end up in different aspects of advocacy or policy development. But Genevieve, as Esther points out, this is often seen as particularly relevant in family law, but I can think of at least sort of 3 or 4 other areas of law like that, which would benefit from this kind of an insight, or at least a framing. Is that sort of drawn into curriculum at the moment?
I think it's actually only in the sort of the beginning stages, somewhat unfortunately. I mean, we have an optional unit in non-adversarial justice, which sort of really focuses on that. But I think when units are optional, you're not getting the coverage of the entire student population, you know. And I think Esther's question or comment is a really insightful one, because it's not just the domain of family law at all. I mean, I think what we do know now is that certainly family violence has an impact on people's experience in a range of different ways, you know, from electricity bills to debt recovery to employment to a lot of a lot of facets of people's experience. So thinking about how those approaches to lawyering might feature in some courses that people might not immediately kind of think of is sort of the direction we're heading in. I think Monash now has a kind of a breadth unit about family violence. It's becoming more and more popular. So I think it's I think it's certainly something that's being recognised.
Louisa, you mentioned earlier that your offer on dealing with difficult clients is always fully subscribed. And I reckon a sort of trauma-informed framing around that would also be incredibly powerful and valuable. And then, as we've said, you know, there are so many other areas of the law where this becomes relevant, and particularly around integrated service provision as well. So is that something that you're cottoning onto?
Oh, it's been in the sector for a long time. And I think that the premise is that all clients who attend CLCs are likely to be marginalised or disadvantaged in some way. That naturally brings trauma with it. It's certainly not the domain only of family violence. All CLC clients will be coming and presenting. Some of those might be financial disadvantage, which comes with trauma. Some of it might be disability or homelessness, things like that. So it's a skill set that's required across the board in CLC work. It's definitely something that is part of training programs that we do. And I want to pick up on your point about the integrated services. A lot of what our CLCs do is to help other allied services to identify when a client's presenting with a legal problem too. So helping a counsellor to identify a legal problem and then bringing the lawyer in, or helping a health professional to be able to do that. And that's really important from the perspective of trauma-informed care, because those people are treating the whole person, treating them holistically with the intersection of their social and their legal issues. So that way of working in an integrated way is part of the way that we support that trauma-informed approach. It's a really important fundamental skill that all CLC lawyers need to have.
Absolutely, and I think increasingly so, and it sounds as if from both you and Genevieve that is very front of mind. Genevieve, Richard's asked another great question about, I suppose, whether or not the priestly 11 are sacrosanct. I mean, how much wriggle room is there, and can they be, to use the pedagogical parlance, can they be breadth units, if you like? Can you take torts and apply it to climate change, as Richard puts it so well?
Yeah, I think that is possible. You know, in most of the ways that the priestly units are described in this these lists, there's basically like a sort of a laundry list of topics, and then often at the end there's sort of a bit of a grab bag that says, oh, you know, but if you don't address those components, then sufficient content to deal with. And then a kind of a much more condensed list. So there is some flexibility, and I think universities have really embraced that to try and make things more applied where they can be. I mean, my sort of litigation dispute resolution course is an example of that. I mean, I don't teach the detail of interrogatories. Like, I'd much rather talk about, you know, the kind of the context for legal problems and how people resolve them and how they don't resolve them and you know, those sorts of things. So there's a trade-off to be made there. I think sometimes it makes universities nervous when the regulators come knocking at the door and say, you know, well, can we still accredit your law course and your law students if you're not teaching the detail of pleadings or something of that kind. But you know, I think as long as we sort of take a lawyerly approach and read the fine print, then we can usually manage. So yeah.
Yes, woe betide the lawyer that doesn't read the fine print.
Yeah.
But we'll take a couple more questions if you've got any on your mind. Please put them straight in the Q&A, and we'll get to them in a minute. So in the interim, in the interest of getting to my big questions about how this thing gets framed, I'm really interested, and this happens in various different parts of the law, that there is a comparator with the medical framework that is drawn from time to time. And, you know, it's often seen as that medicine gets, or the health system gets the money and attention that the law doesn't. And I suppose I sort of drew the parallel with medical education, and I take your point completely, Jen, that that streaming students through the law course itself is possibly not an appropriate pathway. But what about postgraduate specialty, and that we sort of have a basic degree or a base degree, and like medicine, you do a specialty after that, if you like, a sort of an apprenticeship in a particular strand of the law, and whether or not that would prepare people better. And I know, of course, that there are accreditations through the Law Institute and its sister organisations around the country. But is there any discussion around structuring legal training in that kind of a way? Jen, I'll start with you and then maybe go to Louise on this as well.
Yeah, it's an interesting question. I mean, you know, there are master's degrees that people do, you know, to specialise in particular fields. I guess my concern is that legal education is already so expensive, you know, and especially with the kind of the move towards JD degrees, you know, where students have already done an undergraduate degree and then their JD. Yeah, I guess I worry. I mean, I have a sister who's in Canberra, and I certainly know that there amongst the sort of the Commonwealth government lawyers, there seems to have been this kind of ramping up of qualifications, so that a master's is kind of like a baseline expectation, which I think just sounds very expensive to me. I shouldn't say that. I mean, I work in a university. I should be like promoting masters or something, but gee, it's a lot of time and study when people want to, you know, if they're going to practice, they want to get into practice. I mean,
yes,
I expect what will probably happen more and more, given the sort of the shifts that Louisa in particular talked about these sort of integrated services, is that we might see people in fact doing a postgrad qualification in another discipline, you know, to really yeah, I mean, something like public health law kind of comes to mind. I mean, thinking about the value of having a little bit of epidemiology under your belt, you know, when you're engaging with questions around pandemics and the like. I mean, I think that's likely to be something that will happen more and more, I think. And those questions around evaluation, you know, in the CLC sector too, sort of loom large as well. I think more and more people in the sector who develop those capabilities, I think that can only add more strings to the sector's kind of advocacy bow, I would have thought, just to tell you your business, Louisa. But anyway, yeah, just a thought.
Louisa,
all good thoughts. Well, I'm going to come back to you too, because I actually think, Jenny, part of what is a really good reflection of this is those statistics you had about how many people actually intend to practice law versus going into policy or advocacy or journalism even was there as one of the or corporate. So I think that it's a really interesting question, isn't it, when you're designing an undergraduate course where there's such a range of outcomes for the degree itself. We're obviously in this discussion focusing on the community law aspects, but there could be a parallel discussion about, you know, how do law degrees fit in with someone who would like to be a policy person within government in a legal framework. Really fascinating questions like that. So I think,
or a legal researcher.
Or a legal researcher, that's right. So I think that might feed into that sort of conversation about where that heads, what people want to do.
Well, as a lawyer who ran away to journalism, it's always been my understanding or reflection that the law was incredibly interesting as a sort of intellectual pursuit. I loved it and I found it fascinating. But I suppose the concern that I have, which draws us back to community lawyering at its essence, is that so much of what gets taught in the law should be common knowledge. This is stuff that I felt, even at the time, and this is 100 years ago, concerned that what I was learning in admin law or in even constitutional law and torts or contract was the domain of a very select group who managed to get themselves into a law school, and that sort of knowledge about how our system works and what sort of structures we live within was the exclusive domain, and that really shouldn't be, and that concerned me a lot at the time, which is maybe one of the reasons why I didn't end up in the law. That together with that CLCs were not available to me at all. Had I known they existed at that time, I would have taken a very different path, I think.
But Lynn, you highlight there the importance of the legal educations that community legal services do. So going out to communities in plain English, getting people's legal literacy up so that their interactions in the world on contracts, they're informed consumers, they understand rights to walk away from violent relationships, things like that, where people know that the law exists and what it says to protect them. Really important part of what community lawyers do.
We're going to have to wrap in just a minute, but I've got one last question that I thought I would to all of you. The profile of CLCs, I think out of the data, it was interesting to see, how many people were conscious of the fact that, that CLCs perhaps were not necessarily highly rated as a career path in their experience of law schools and legal academics. And Jos, as you put it, how important it was to have, that, like you're having your great teacher in year 9 that turned you around in maths, having that lecturer at law school who made you aware of other opportunities in the law was really quite powerful. Did that come through strongly for you as when you read all the qualitative stuff?
I think for when we did look at the qualitative answers, especially in other sections of the survey, it's kind of what really came across is that people had actually found their tribe. They had found their calling and they'd found the place where they could work, where they could make a difference. And that even though they may not be earning as much as, what they think other people might be earning, that for them that was, well and truly worth it, So it was kind of, inspirational, even though they kind of talked about all the issues in terms of funding and, I think about half of them were on short-term contracts or, renewing contracts and not continuous contracts and things like that. There was that overwhelming sense that they were committed and dedicated and got such, a huge amount of value and satisfaction out of the work that they did. And that, in fact, that, other people not working in the CLC sector would actually fail to appreciate that. To fail to appreciate that great sense of value that they could achieve in working in that sector. And it's kind of interesting, I think about, perhaps the placements, and maybe Genevieve and Louisa can talk about this, is that when you're a student, you're a bit kind of pragmatic, right? And you think about, I'm going to volunteer here and volunteer there because it's going to go on my CV and I'll be able to, be better placed to get a job. And kind of like in financial education as well, I kind of think, I'm going to do this savings program because I'm going to get some match savings and get some money. But what happens perhaps like in those match savings programs, and I wonder also with the placements, is, they might be doing it for a very practical, strategic reason, but they actually get in there and go, oh, wow, this is amazing. I really want to do this, or I've learned so much through this that this is going to help me later on in life. Unfortunately, we didn't really capture that in the survey. We'd need to, dive again into what people, said about their placements. But that was certainly, whether they did their placements for that strategic purpose or because that was where they were, particularly focused, is actually intriguing because the people that were there were absolutely dedicated to the work that they were doing.
Very sadly, we are out of time. So I'm going to, unfortunately, not throw my final question to Genevieve or Louisa, not even yours, Josica, either. But I am going to give the last word to the person who is the CEO of the peak body for CLCs in Victoria. In terms of the profile of CLCs and getting the word out that this is a really valuable way in which to fulfill your aspirations, both as a lawyer and as somebody committed to community and social justice. CLCs is an incredible pathway. You are doing an amazing job in raising its profile and getting it out there, but what more needs to be done in 90 seconds or less?
What's interesting, I was reflecting on another part of the workforce survey talked about where you worked before you came to your CLC, and a remarkably high number actually had come from private practice, from commercial firms. I think it was around 16%. Was that right, Josica? So people are starting to see CLCs as a place to go to. I'd actively want to come and work there. I think profiles need to be raised at the student stage so people understand it as a long-term career path. Over the years, there's been graduate programs in some CLCs and also organised by the Federation. I think graduate programs within CLCs where you get that practical legal training as a young person is fantastic. I think opportunities like this where we share and discuss the findings of the research that we've done. This research is fantastic. It really highlights the passion that people have and that it's a really positive place to be working, and people love working at CLCs. 83% of people said they do it to help people. So if that's part of what is driving you to study law, that can be something that you can look at as your career pathway. So work like this and sharing it more broadly is a really fantastic way to raise the profile. So thank you to the Victoria Law Foundation for that opportunity.
The opportunity was offered by you, so thank you very much.
We couldn't do the research though.
No, that's a happy partnership. And thank you to everybody who's joined us for this conversation. It's been a lot of fun, and I hope that that you've had some useful thoughts and insights as a result of the presentations from Josica, Louisa and Genevieve. Thanks to all three of you so much for all your work on this. And we will throw back to the Law and Society Association of Australia and New Zealand and thank them very much for the opportunity to present this panel as part of their annual event. Have a splendid afternoon and a lovely weekend, and go well.